Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. Interesting show we've got for you. Father's rights, all about it. If you know someone who you think might be interested in this show, pick up that phone, give them a call, and just kind of let them know, give them a heads up, because this show is a little bit different. And we're not exactly sure where it's going to head, but that's okay. We're all right with that. Josh Wright from the firm of Hollis Wright leading our conversation. We're kind of
the show rolls.
That's it. Yeah, we're going to just make it up as we go.
We don't shy away from controversy, things that are politically correct. We just kind of hit it head on. You know, this is an interesting topic. We have done, over the last 5 years, David, a lot of shows related to custody, related to asset division, related to divorce. And we're putting a different spin on it today, which is, and we're very lucky, we've got Greg Starkey that runs the Birmingham men's law firm. And we're talking about men's rights in divorce with custody, asset division, etc. And Greg has dedicated his practice to that exact area, helping men in times of need when it comes to these types of things. And so first, thank you for being on the show.
No, thank you for having me.
And I know you've heard Greg
that voice
all over.
Familiar.
I mean, you can't miss that voice. It's all over the radio. You've seen him on TV. He's been a staple in this area of the law, and we're just glad to have you on. Tell the viewers, just in general terms, how did you get involved in this specialty? Because this truly is a specialty.
Josh, back before I started practicing law, I went through a divorce. And so when I started law school, probably about 15, 16 years ago, when I started law school, one of the things that interested me was divorce law. Very interested in all the case law and how divorces would be litigated. So I knew that I wanted to be a divorce lawyer when I graduated, but when you graduate and you go out on your own, sometimes you're not able to practice in one area because you're trying to make a living. So you start practicing whatever areas is going to bring in the money. But, eventually I was able to narrow my focus down to divorce. And then ultimately I was able to narrow my focus down further by representing mostly men. We do represent some women sometimes, but mostly we represent men, because quite honestly, I think that a man that, he's worked hard his whole life, if he believes in the traditional marriage, he's normally dedicated himself to his work. He may work long hours. If he's able to afford it, he has his wife staying at home raising the kids. So when they decide to get a divorce, he's really behind the eight ball, because the mother's been raising the kids, so more likely she's going to get custody. She's not working, so more likely he's going to have to pay alimony. So a lot of times he finds himself in a worse position by trying to do the right thing than if he was, if he had a sketchy work history, he was able to stay at home and his wife had to work because he wasn't supporting the family, and that guy might come out better than the guy that's tried to do the right thing.
Where do you see most of your cases come in? Do they come in a divorce context? Do they come in a custody circumstance, or both?
Most of them come in through a divorce. Okay. And quite honestly, probably 80% of our divorces the wife has filed. Okay. And he comes in he'll come into our office, saying, hey, what do I need to do? I've been served this divorce complaint. Where do we go from here? Now we do have some cases where we represent men that's been in a relationship where they weren't married, and then you have issues that concern custody, visitation, child support. We represent men in that also, but that's usually done in family court and not in domestic relations court.
Let's hit some topics that I know people talk about in the context of divorce a lot, and they may have some misconceptions of what the law really is. For example, I've heard this concept that you can only get alimony in Alabama if you've gone through a divorce after you've been married 10 years. True or false?
That would be false.
Okay. Explain that to me. In general terms, tell us a little bit about kind of in general what alimony is and how it's created, how it's decided by the court.
Well, alimony is basically an amount that one spouse is going to pay to the other spouse after they went through a divorce. Now, there's a couple of different types of alimony. There's periodic alimony, which is usually paid to maintain the other spouse's lifestyle, basically until they either die or remarry. Then there's alimony in gross, which has more to do with the property division, but I'm assuming what you're probably talking about is periodic alimony. What happens is there's really no cut and dry law when it comes to alimony, but there's several factors that a judge will use in determining whether there's going to be alimony, how long it's going to be paid, and how much. And some of those factors are the length of the marriage, how long the parties were married. Obviously, the longer the parties were married, the more likely there is to be alimony. The differences in income. In my previous example, you've got the man that's out there working. He's earning a good living, and now he's had his wife sit at home and raise the children. Well, he's in a lot worse position as far as fixing to have to pay alimony than if you've got two parties that are both working. The age of the parties, the health of the parties.
So it's really discretionary with the court.
Yeah, it's very discretionary. There is no formula to determine alimony, and quite honestly, a lot of times it's litigated. It's not settled because there just really is no set law to determine the amount of alimony.
A question we've got here from some viewers, and if you want to join in, that information at the bottom of the screen, ways you can call, text, email. Also, attorneys are standing by live right now to take your calls, so take advantage if you have a question. A question we have here: in a circumstance where a child's parents are not married, does the father and mother have the same legal rights to the child?
Good question.
It depends. Now, if they've never been married, then technically the father is the natural father, but he's not the legal father. Okay, the only way he can become the legal father is if they were married at the time the child was born, or if he goes to court and has the court issue an order of paternity. So basically what would happen would be if a man and a woman get together and they have a child, they're not married, the woman has a child, okay? At that point, his only contact with that child is going to be at the mother's discretion. He has no rights to visit that child. He has no rights to make any legal decisions for that child. The way to become a legal father is he would have to file a petition with the court to determine the paternity and also to establish visitation, custody, and normally the court's going to establish child support at the same time. Once he files that petition, the mother would be served, and then the court would set a court date for it. Then they would go down there and have a paternity test done. If it comes back that the father is the natural father, then at that point, the court's going to issue an order of paternity, making him the legal father, and then they will move forward from there and establish child support, custody, and visitation.
And that's a good stopping point because I know we're going to break.
Yeah.
When we get back, I want to talk with Greg about child support, the schedule that's written into the law, and kind of how that works in general terms.
All right, we're going to step aside our first break of the evening. Again, a reminder as we do so, a subject matter tonight, maybe you got a question about it, would love to have you join in the conversation. Live attorneys standing by right now to take your call. Also, other ways you can get in contact with us here and the law firm of Hollis Wright. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple.
provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Another first here on The Attorneys, family law and specifically fathers' rights tonight. We'd love to have you join our conversation. The information how you can be a part at the bottom of your screen. Also, don't forget, live attorneys standing by right now to speak with you. Josh?
Talk to us, Greg, for a minute about how custody works and how support works. Maybe let's focus our attention on support. It's codified, isn't it? It's in a statute, and there's some guidance that a court has.
Child support is determined by the Alabama Child Support Guidelines. Okay. Basically, unlike alimony, child support is pretty much, like you said, codified. That child support amounts can usually be settled because they're done by chart. Now, the way they figure it is they'll take the father's gross income, including any overtime or bonuses that he might get, and if those bonuses and overtime is fairly
just consistent.
Yep. Then they'll count that as his gross income, gross monthly income. Then they take the mother's gross monthly income and they'll add those two together to come up with the total gross income of the family. Then you're going to go to a chart, which is where the Alabama Child Support Guidelines come in. There's a chart. You find the total income on the chart with the number of children, and then that's going to give you a total child support amount. All right. Then you're going to add in cost of health insurance on the child or children, and any cost of daycare. Then you come up with basically a grand total, and then whatever party's paying the child support, whatever percentage of the total income they make, that's going to be multiplied times that grand total. And that'll be the child support that they're going to pay, less any health insurance costs that they're paying or any child care costs that they're paying.
All right, so I know we will get questions to this because we always do whenever we do shows related to divorce, child custody, child support, etc. We talked earlier about alimony. Mm-hmm. If somebody's receiving alimony and they get remarried, does the alimony end?
Yes.
Okay.
The alimony does end.
Okay. Now, same thing with support, because we'll get this question. Let's answer it now. Just because a spouse who's not paying child support gets remarried does not impact the support requirement and responsibility, does it?
No, it does not. The child support is determined only by the mother and father's income, not by their spouse's income.
Okay. So in short, once you have a support obligation, does it end at some age? How does that work when support would end? And I'm talking about the actual support. I understand that when people get divorced and they have support requirements that they want to help their children regardless, get through school, etc. Yeah. But when does the legal component to support generally end?
It ends when the child reaches 19.
Okay.
Now, and technically, if you're paying support directly to the mom, the child turns 19, or if the mom's paying support directly to the father, when the child turns 19, you basically stop paying child support. Now, if you have an income withholding order, which quite honestly most people that pay child support do it through an income withholding order where it comes out of your check. When the child turns 19, you would basically file an affidavit with the court saying that the child has turned 19, and the affidavit would be to terminate your income withholding order.
All right, and let's talk about the ability, if the husband and wife split, there is a child, how does custody and visitation itself work? Is it still based on the court? Like, does the mom have the advantage from a custody perspective generally, or how does that work?
Generally, they do. Unfortunately, like I said, if you've got a man that has worked hard his whole life, he naturally hasn't been able to spend as much time with the child as the mother, then usually the mother's going to have kind of the upper hand when it comes to custody. In theory, both parties come into the court on an equal footing, and custody is determined by the best interest of the child. And some of the factors are the age of the child, the sex of the child, the relationship that each parent has with the child, the relationship that the children have with each other. But I mean, primarily it's going to be who was the primary caretaker of the child, and that's normally the person that's going to get custody. Then if let's say the mother gets custody, then the father's looking at a visitation schedule.
And I was going to ask you, talk to us a little bit about visitation, how that schedule generally works.
It varies a little from court to court because different counties and different judges have variations of a standard. There's not really a statewide standard, but normally it's say the first and third weekend from Friday to 6 to Sunday to 6. It's going to be 4 weeks in the summer. It's going to be a week at Christmas, every other spring break, every other Thanksgiving from Wednesday to Sunday, and usually the father's going to get the child for so many hours on Father's Day and so many hours on the child's birthday. Okay. Now, one thing that we strive to do is, if the father's in a position just to get visitation, that we strive to get to expound on that standard. So let's say what we would strive to do is to have a visitation schedule set up so that not only is the father getting every other weekend, but let's say he would get one evening every week.
Gotcha.
So he would get, say, to pick up the child on Tuesday afternoon and then drop the child off Wednesday morning at 8. So that way he's able to maintain some kind of weekly contact with the child, and he's not going 2 weeks without seeing the child.
Ultimately, it comes down to what the best interest of the child is. And the court gets to kind of reach that conclusion.
Unless the parties come to an agreement, then the judge is going to make that call.
When we come back, one of the things I want to talk about, because I know this issue comes up a lot when we talk about divorce and custody and support, is what happens if one of the spouses wants to move that has primary custody or has sole custody. What responsibility do you have to report that to the court? And what circumstances are you more allowed to move versus those that you aren't, like a job move, something like that? I think it's an important issue that comes up a lot with custody and support. We'll talk through it.
All right, we'll step aside. This is our final break of the evening. So if you've got a question to ask, now's the time to do so. Take advantage of the opportunity. Again, live attorneys standing by, and all the contact information you need right there on your screen. Also, you can find the firm if you'll search Hollis Wright on Facebook, and on Twitter, they are at Hollis_Wright. Stay tuned. More of the attorneys coming right up.
I'm Tyler Vale with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 411, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Rule 403 of the Alabama Rules of Evidence states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there is sufficient insurance coverage or assets to satisfy a verdict. The reality is this. The parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during a trial, there could still be resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the Attorney's Hour, final segment here. So if you've been waiting the entire program to pick up that phone and make a call, wait no longer. The clock is ticking. The contact information you see there on your screen. Would love to speak with you. The attorneys of Hollis Wright standing by right now to talk with you as well. Josh?
We really do answer those questions too.
Absolutely.
I mean, we've been talking about this last several shows. I mean, we get thousands of calls, texts, emails per year, and we answer those things. And the best part about it is, we don't know the answer to a lot of stuff because it may not be within the core things that we do as a law firm. And that's a good example tonight that we bring Greg Starkey on because he's the divorce expert. Right. So if we have a divorce issue, we will get you to the right person for sure to get a consultation to kind of understand
Take advantage of that.
Take advantage of it. Please take advantage of it. All right. When we went out to commercial, I mentioned that I want to talk about the ability to move. Does a spouse that has custody have the right to just kind of unilaterally decide to go move and bring the child with them? Do they have to get court approval? Do they need approval from the other spouse or the ex-spouse? How does that work?
In Alabama in 1999, the legislature passed the Alabama Parent-Child Relocation Act, which basically states that in the case of a divorced couple, if the spouse moves with the child, they have to give the other spouse notice 45 days before the move, and they have to do it through certified mail. At that point, the other spouse has 30 days to file an objection to the relocation, and they have to do that with the court. They can't just call the spouse up and say, I don't agree. They have to file it in with the court. And once it's filed in with the court will hold a hearing on it and basically will determine what's in the child's best interest. Now, some of the factors they look at is, if you as a father have been paying your child support consistently, you've been visiting with the child, you maintain a relationship with that child, then more than likely the court's not going to allow the mother to move with that child. Now, the court can't keep the mother from moving, but the court can keep the child from moving. Now, on the other hand, if you haven't paid child support and the mother's moving for financial reasons, then the odds are that the judge is going to allow the move because it would be in the child's best interest because you haven't paid child support.
Does work relocation have an impact on the decision that the court ultimately makes?
It can, yes, it can. It comes in. It comes in under the financial aspect of it. I mean, the judge, and that's going to be a hard call for a judge.
Yeah.
If you're looking at the mother's going to move and she's going to better her life and the child's life, but then you got to balance that against the disruptiveness of the relationship that it's going to have between the child and the other parent.
Greg, it sounds to me, and we've done some divorce shows before, but it sounds to me like the court is really almost a mediator a lot in resolving these disputes and issues that come up to try and maintain the best interests of the child on a moving forward basis.
It really is. In fact, most divorces are never really make it to trial.
Gotcha.
Most of them are mediated or settled. They can come in, the attorneys, you have two good attorneys that know about how the case is going to come out if it goes to trial. Normally those two attorneys can settle the case without having to have a trial. A lot of courts now are ordering mediation, where you have a mediator come in and mediate the divorce decree. And it usually works a lot better than a trial, because in a trial you're going to put all your evidence on and usually within about 3 or 4 hours. And the judge is going to make a decision that's going to impact both parties for the rest of their lives. Whereas if you come to an agreement or you mediate out an agreement, then you have a lot more control over the outcome of your divorce decree. Now, you're not going to get everything you want. Neither party does. But you can make sure you get those things in there that's important to you that you might not be able to get in if the court just enters
Decides
an order.
it. Yeah.
Less than 3 minutes remaining, but I want to get a question in that we've got. What if the last court order states that the mother has custody of the child and the child has since moved in with the father? Does child support automatically stop?
No, it does not. Now, the court can only enforce its last order. So, I see this happen a lot where their child support set when the child's young. As the child gets older, the child wants to live with the other parent.
Right.
So the child moves in with the other parent quits paying child support. There's been no court order changing that original child support order. So technically that child support keeps going.
Yeah.
And then if one of the other parents decides, hey, what about all that child support you owe me? Take them back to court, then they're going to owe not only the back child support, but they're also going to owe interest on that also.
I know this is a little off topic, real quick. Where are we on grandparent visitation rights? I know there was a period where there was no grandparent visitation rights, and then they tried to create a law that allowed it. Is there a change in that law, or is it right now still where it used to be, which is grandparents don't have any legal visitation rights?
There's been a change in the law, but it's very narrow.
Okay.
In order for a grandparent to have visitation, they have to show that they've maintained a very close relationship with that grandchild up to the point that they file for visitation. And they also have to show that it's in the child's best interest that they continue to have that visitation. Otherwise, it's going to be destructive to their physical or mental well-being. So it's very narrow.
I just answered 10 questions that we were going to get texted tonight, right there.
Hey, real quick, a minute remaining, but want to give both of you an opportunity. Just a final thought from you, just a few seconds.
I would say if you're involved in a divorce or you've been served with child support papers, always consult an attorney before you move forward. It never hurts to get all the advice you can, and most attorneys don't charge you for the initial consultation, so you can go in and kind of get an idea of where the process should go from there.
Yeah, the only thing I'd say is, as a lawyer, we see things from all angles. This is a unique angle today, which is the men's side of it. There's a woman's side too, and then there's a joint side. I've loved doing the show because I think it's good to get perspectives from all around. Greg Starkey's a great lawyer, does a good job in this area.
Appreciate the time, gentlemen. Also, thank you so much for being with us tonight. As we wrap things up, here's how you can get in touch with the firm of Hollis Wright if you should have further questions. Thanks so much, and we'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.